You're live.
Okay, good morning. We're back in Senate Judiciary. Weird little thing here. We're not technically taking up S-261 and path crossover. However, there was a request from the Transportation Committee that we review the language because it involved liability, and they would intend to, depending on how the committee process goes, attach the language, I believe, to the miscellaneous transportation bill. So, in other words, this is us doing a drive-through, fly-by of the language that may get attached to another committee's bill. So we have Ledge Counsel here to box this.
All right. Thank you. For the record, my name is Daniel Leonard. I'm the Office of Legislative Counsel. The bill in front of you is relatively short, but it's part of a bigger legal scheme that you would find in 12 VSA Chapter 203, which is limitations on landowner liability. And that chapter is Vermont's version of what was a model act put forward by the Council of State Governments to essentially address landowner liability when landowners make their land available for recreational use. So, for example, allowing a trail to cross their land, and they're not charging a fee for that use. So this is different than, for example, a ski resort that might charge for lift tickets, or a mountain bike area that charges for a trail use pass, etc. This here is specifically for those trails that you might find around Vermont that cross people's land through an agreement between the landowner and a trail organization. And what this would do is it would add to the definition of land for purposes of that statute, railroad property, railroad rights of way, and utility corridors to which public access is permitted. So, and this is based on changes that were made to similar statutes in Massachusetts and other states. The general idea being that this would open up railroad corridors that have not been rail banked. And rail banking is this process where we keep the railroad corridor, but it's essentially being banked for future use, and in the meantime, it can be converted to a recreational trail. So that would be your Lamoille Valley Rail Trail, your Beeb Spur Trail. There are a couple of these trails in Vermont. The Causeway in Burlington, the rail trail that goes out of Burlington and across the Causeway is another one. This one would be actively owned by the railroad, but they're not currently using it, or it's wide enough that they can run a recreational trail alongside the rails in some cases, and they're willing to do so. And so this would insulate them from liability. And so the language in the statute that insulates from liability is probably the important thing for you to be aware of. And that is section 5793. And it provides that an owner shall not be liable for property damage or personal injury sustained by a person who, without consideration, enters or goes upon the owner's land for recreational use, unless the damage or injury is the result of the willful or wanton misconduct of the owner. So in other words, the owner has intentionally left a hazard there or wantonly left a hazard there that causes the injury. And that it also extends to property damage or personal injury sustained by a person who, without consideration and without actual permission of the owner, proceeds to enter upon or use equipment, machinery, or personal property, or structures or fixtures that are on that property. So in other words, let's imagine that you have a trail that crosses farmland, and someone leaves the trail and goes on to a piece of farm equipment and then injures themselves. The farm equipment was not negligently left in the way of the trail or something like that. The person has departed from the permitted use area and is now without the farmer's invitation, climbing on the farm machinery and falls and breaks their arms, the farmer is not liable for that, is essentially what this is providing. So by extending this to railroads, this would insulate railroads if they open up their corridor or a utility. So this could also extend to a utility corridor with like power lines or something like that. It would insulate them from liability for injuries sustained by people using a trail along those corridors, as well as people who proceed to climb upon things or use other sort of equipment or machinery that's left on that property that is not there as a result of willful or wanton misconduct of the owner. And I do have a court decision handy that explains what the courts have held that to mean.
Can I just ask a clarifying question here that I think will make a world of difference in how I feel about this? So this only applies to land that, in this case, railroads that are not currently being used for railroad traffic.
It could include, so this could, if the railroad chooses to open up the property, if they have a right of way that's large enough. So the rights of way can differ in width. And so there are instances, and this would be up to the railroad here, is if they have enough space in their right of way to run the rails down, and the rails are running along one side, and then there's enough of a gap that they feel comfortable allowing a recreational trail to build parallel to the rails. That could occur. So there are examples of that. And I don't know if it's covered under a statute like this in these other states, but I've seen examples of that in places like Maine, where there's a bike and pedestrian path alongside rails, and they're separated by like a chain link fence to keep people from crossing onto the railroad right of way. But yeah, it may be worth hearing from the sponsors of the bill on particular things that they envisioned, but it would allow railroad to say, we have 100-foot right of way, we're only using 30 feet of it, we're fine if you run a recreational trail and build a fence to keep people from crossing into the railroad.
Yeah, I know, I don't want to speak for Senator Harrison, but I know this was something that was brought up due to I don't want to say a situation, but due to a situation in Brattleboro where there's a railroad that's not being used and the town's trying to figure out how to use it as a recreational space. That's the general impetus for this.
In that instance, you can have a railroad that says, yeah, we're not using that corridor right now. It's fine if you build a path there, but we're extending the right to use it pursuant to an agreement that says we can terminate it if we reopen the rails too. So there's that option as well.
Can you help me understand what the courts said wanton, whatever that language was? Because I have some specific questions, but maybe they'll be answered in that explanation of that court finding.
Let's see. Okay, so the courts have the legal standard for wanton and willful misconduct, and this is from a Superior Court decision in a case called LeMay v. Bessa, in which an individual was on a farmer's property without permission, driving down a farm road and hit a cable extending across the road that was intended to keep trespassers out, and suffered severe injuries. They said that the court here wrote that the legal standard for wanton and willful misconduct is conduct manifesting personal ill will or carried out under circumstances of insult or oppression, or conduct manifesting a reckless, wanton disregard of one's rights. And so it then went on to assess the case, saying that there was no evidence in the case that the landowners harbored any ill will towards trespassers on their property or otherwise intended the cable to act as a trap and to injure trespassers. So this, in that case, they found that this wasn't that. They found, that the landowners had marked the cable with stuff to make it more visible to people who were traveling down the roadway, etc., in an effort to actually prevent injury rather than an instance where, for example, they hid something to cause injury. So that's sort of the standard there, is that if you have intentionally left a hazard there for folks who are using that, the recreational path.
So it sounds like it would not cover gross negligence, recklessness.
So, yeah, the Vermont has two cases construing. One is a Superior Court case, the one went up to the Supreme Court. Two cases construing its law. I haven't had a chance to look at how other states have dealt with the issues of gross negligence. And Vermont's cases don't deal with that. And in the one case that dealt with actually reached this law, it was the trial court case, and they found that there was no that they didn't owe a duty of care and that they weren't liable because they hadn't engaged in anything that exhibited ill will or intent to harm. The other case on this found that it wasn't under this statute because the road in question was not open to members of the public. And that case related to a homeowners association that maintained a private beach, and again had cable extending across the road to the private beach, and a member of the homeowners association on their dirt bike struck the cable, and again suffered serious injuries. But they found in that case, because it was a private road, and this was a member of the private group, and the road was not open to the public, that recreational use statute didn't apply, and so that went on. It got remanded to the trial court because the limitation on liability wasn't in place at that point, and they reconsidered liability, and I don't know how that case resolved. And so there's no trial decision available in Westlaw. There may have been a decision, or it may have been settled after the Supreme Court ruled that the homeowners association wasn't insulated by the statute from liability. Yeah, so we have very limited case law to follow on this. I can look into what other states have held about, for example, gross negligence. There are some other cases in Vermont, but I think they may predate the adoption of the statute related to the duty of care owed to someone who's trespassing. And there was one case in a cemetery where a child climbed a tree from inside the cemetery, fell on the cemetery fence, which is one of those old wrought iron, very sharp fences. And so there was a question there, but I did not think into that case because it predated the statute.
And this is so, transportation is not my area of expertise.
This is in that gray area between transportation and judiciary.
But I'm wondering if you have any sense of who are the people we're talking about, the railroad companies, the utility companies? What is the scope of what?
So the scope here would be so Vermont has two types of railroad corridors, those that are owned by the state, and then those that are owned by small railroads that operate in the state. And so that would be the Vermont rail system is probably the largest of those. But these are short line railroads or short line railroads that belong to a larger company that operates short line railroads. And those are distinguished from like the major railroads like CSX and Union Pacific that we're probably all more familiar with. These folks bring the stuff from the mainline railroad out to, down a shorter line to places like, to or from places like Barry, Rutland, Burlington, et cetera. So that's what we have in the state. Over those railroads, you have both passenger rail like Amtrak and these smaller freight operations happening. The state owns some of the corridors, but it does not operate on railroads there. And then the state owns all of the rail-banked rail trails, the Lamoille Valley Trail, et cetera. Those are generally owned by the state. And they're subject to this federal rail banking law that allows the rails to be basically preserved for future use for storage. So those rail trails would be replaced by rails again at some time in the future if the traffic increases. And that's part of the federal scheme to ensure that we don't lose that capacity, whether that's actually likely to happen or not.
Okay, and you may not know the answer to this because utilities are not a transportation thing, but they are in this bill. What are the utilities we're talking about?
So the utilities that we would be
Corridors or whatever.
talking about here, the most likely one I can think about would be your electric transmission utilities. I don't know if for example, Vermont Gas has any corridors or would actually want to open any of their corridors up for recreational travel. With the electric utilities, you may have instances, and again, I can't speak for them. And I don't know if any of the rights of way in Vermont are conducive to it, but you may have instances where under a high tension wire, you could have a trail that's open for recreational use.
And if that wasn't properly cared for, it fell on someone using it, they might not be liable for that because it wasn't wanted. It wasn't intended to do harm.
So the question is there wanton misconduct of the owner? It does also allow an owner to post signs warning of dangers, and then eliminates, again, insulates from liability if you posted signs warning of dangers. For example, if there's a water hazard within the right of way, a no swimming sign. If there's an electrical corridor, a fence or sign that says keep off high voltage. So yeah, these are liability protections, and it doesn't seem to just double checking. It doesn't seem to go address that issue of negligence. The additional statute there provides that this doesn't supersede or replace any requirements around animal control, at least in ATVs. It doesn't limit the ability of the owner of the land to enter into agreements that modify their rights. So there could be some provision for maintenance, et cetera. Doesn't support claims for eminent domain or adverse possession. It does not relieve persons making recreational use of the land from the obligations that the person may have to exercise due care for the person's own safety in the recreational use of the land. So a lot of it goes back to if you're using this land, you would use your own risk and exercise care when using it. But I don't know if there's case law that in other states that has extended negligence claims. In this case, if there is an instance of negligence. It is important to note that these limitations do not, all of that chapter doesn't apply to municipal or state-owned land. So for example, Burlington Electric or the state rail rights of way would not be covered by this change. This is purely private companies opening up their rights of way. So.
Fair north.
Yeah.
I do have some clarification in that. My understanding that the Memorial Valley Rail Trail and the Cisco Valley Rail Trail are owned by the state of Vermont.
Those are the state of
So
Vermont.
they'll fall under this. So if you talked about utility corridors, I'm not aware of any utility. I would hope people other than GMP or whatever else, they can have permission to use your corridor. It's my understanding that they have a right of way 50 feet both north and south of the pole to keep it clean. But if that utility had to go through, this is the question, post property, utility can give somebody
No,
permission to
they're not
use
the
their
landowner.
corridor down the landowner.
Yeah,
That was my question.
yeah, so, if you have private property that's posted for no trespassing and you have, this may be something you want to add as, if you would want to add as a clarification too, is just to say that this does not extend to, easements to run the utility lines across, individuals' property. For example, in some of the towns near here where you have an easement through a farmer's field and over a hill through someone else's woodland to get to the cluster of houses in the next village, because it was easier to run the wire that short distance than to run it out along the roads. If you remember from the windstorm we had a few years back and the time it took to repair the Washington a lot of lines because they ran across sort of the backlands, because when they were building it out, that saved materials and costs at the time.
So when would this come into play then? I mean, generally speaking, utilities don't own the properties that these easements go through.
I think my understanding from other states is that this is related to the utility corridors that you see around like high tension wires, where it's broader, a wider corridor, where they own the land underneath. But this language was taken from other states, and it could also just be dropped out, so it's just rail corridors, if that's the focus here.
I guess it's to answer my question.
Yeah.
Would it apply to the state of Vermont? Are there any utility corridors owned in the state of Vermont?
The state of Vermont is expressly excluded from the coverage under this chapter, so it wouldn't apply to the state itself. But if you could apply to, if there's a private utility that owns its land. Yeah. So the language in here, the railroad property, railroad rights of way, and then the utility corridor. I think that term, I think you've highlighted some ambiguity in that term. So if this did move forward, and you decide to keep that language in there, you may want to clarify what a utility corridor is and clarify that it doesn't include, for example, the easement to a line drop or, an easement across private property. It could just simply be written utility corridors owned by utility.
Yeah. I think we have to make that clarification.
Yeah.
Or suggest that.
Yeah, and I mean, I think your committee has the bill, but the discussion is adding this language to the T-bill as an amendment to that. So, if the transportation committee thinks that it wants to move forward with considering this, I just want to recommend that they make those changes to any language.
Personally,
I'm not sure.
Yeah, I mean, my initial thought is to just remove utility corridors and to just have it be railroad property, railroad rights of way.
I'm a little concerned about how broad the liability coverage is. I mean, railroad property, and when I look at it, would be more dangerous inherently than offense. Than offense, which is one of the things on the list that gets this liability. I'm kind of concerned with the whole concept, particularly the broadness of it, given the potential hazards or lack of maintenance and negligence not being covered. It really kind of concerns me.
I think I had the same thought, but I guess the question to Damien is, generally speaking, public isn't permitted on railroad property. Right.
Yeah, so right now, if you enter on railroad property, you're trespassing.
So it would only then apply, like you described earlier on, places where there's trail right next.
They would have to choose to open up a portion of their right of way for their property to public use.
Yeah.
Public recreational use. So that's hurdle number one. And only after that would they have this liability insulation.
But they don't have any obligation if they can be reckless and negligent or grossly negligent to ensure that that property is now safe for the public.
And then, in looking at this statute and just the statute, or I do not see language in here that would address, for example, negligence and maintenance of the structures on the property to the extent that those are the responsibility of the railroad. There is language that allows them to enter into further agreements, for example, with the trail organization, which could include that the trail organization maintains the structures and other parts on the property, but it does seem to provide liability protection for the landowner. My understanding of the history of these laws around the country is that they were intended to get more private property owners to open up their land. And then this bill, as I understand it, came out of a move in recent years in certain surrounding states to extend this railroad property. And so this mirrors some of that change. What I don't know off the top of my head is whether those towns either have clear provisions on negligence related to landowner negligence or case law addressing negligence on the part of the landowner, gross negligence, and where that line is drawn. And we don't have enough case law in our state. That question has never come up.
So all we're saying is railroad property is already off limits. This is, on the statement of this bill is, if the railroad wants to open up portions of the rail trail for recreation, is because someone has approached them, they're going to maintain it, whatever else. They're being a nice neighbor here saying, yeah, go ahead, you need to maintain it, if it would only a liability on it. So I can see where they should be held liable in the case where they don't have to do this, but someone approached them and said, yeah, it's your walking trail in here, whatever else, you do what you're going to do.
Yeah, and so the question of negligence may come down to, is the railroad still actively using that corridor? And if so, are they, the way it's worded, it doesn't prevent that. There may be other provisions and other statutes and requirements that under federal law, for example, that could prevent that use. And prevent them from opening up. Certainly, if there's a safety issue for the operation of the trains, I can't imagine that a railroad would be willing to, consider opening it. But if you're talking about an unused section of track that they may be willing to open up for recreational use, then they may just agree that any negligence claims would be the issue of the trail organization that's now maintaining the trail on it.
You remind me what claims are prohibited under 5793.
So 5793 provides that the owner shall not be liable for property damage or personal injury sustained by a person who is without payment has entered or gone on to that owner's land for recreational use, unless the damage or injury is the result of willful or wanton misconduct of the owner. And so that's the general provision here. And currently under that statute, your land that's covered by this is open and undeveloped land, including paths and trails, water, including springs, streams, rivers, ponds, lakes, and other water courses, fences, or structures and fixtures used to enter or go upon the land, including bridges and walkways. So that's what's currently covered. It does not include areas developed for commercial recreational uses equipment, machinery, or personal property, and structures and fixtures not described in the fixtures that are included, like bridges and walkways. However, it does then provide in the liability protection that unless the damage or injury is the result of willful or wanton misconduct of the owner, an owner shall not be liable for property damage or personal injury sustained by a person who, without the actual permission of the owner, enters or goes upon the owner's land for recreational use and proceeds to enter upon or use equipment, machinery, personal property, or structures and fixtures that are not described in the definition of land, as in bridges, and walkways.
So just to follow up to that, then Senator Connors, so if land does not include equipment and machinery, and somebody is walking along, for some reason they go off the trail and they start walking on the railroad itself, they get hit by a train. I'm seeing machinery and equipment in that scenario. So would that liability protection no longer exist because it involves equipment and machinery?
So if they're entering on the railroad without the permission of the owner of the railroad, the owner is still protected from liability.
Okay, so
What that,
one more scenario and then we'll start.
yeah,
All right, so let's say person stays on the trail, they're minding their own business, not doing anything. Train comes along, it wasn't maintained properly. The engineer was negligent. A piece of equipment comes off the train that shouldn't have come off the train. Hits the person, disables them. They get a physical injury. They've been affected by equipment or machinery from the train due to negligence. So would they then potentially have a claim?
I think at that point there is potentially a claim. I think there's still a fairly strong argument that there's liability and protection for the railroad operator, but I think at that point you could argue that the negligent operation of the railroad equipment that then caused the equipment or cargo to enter the recreational trail and harm the individual could result in a negligence claim for personal injury. But I think it's still, the way this is worded, it is a pretty broad protection. And I think there's certainly, I think the railroads have a colorable argument that they are still insulated. And that may be your question here is, does it, and again, this gets into the policy question here. Should it be all railroad property? Should it be just property that's not actively being used for rail operations? And are there differences, for example, between, building a bridge that passes over an active railroad operation versus running a recreational trail alongside, but not dangerously near an active railroad operation? Again, I conceivably that I can't imagine a railroad being okay with having folks walking directly next to the train. I have to imagine that this is an area where there's enough separation or some sort of barrier in order to ensure that there's safety there.
Yeah, three quick ones. One is, did anybody take testimony from?
No, this is the first testimony. So, I mean, certainly before, this moves forward, you may want to hear from railroads as to whether this is even something they would be open to.
And secondly, come on here, routine railroad truck, how far the easement is, the railroad on both sides, I don't know.
So they would have a much better sense of what the range is, whether this even makes sense in Vermont, and whether this would be something that they would even consider on active properties versus properties that they own that are not active. in active use.
And my final question is on line 7. I mean, I don't even know why the railroad would even entertain this, because it simply says that this bill proposes to limit the liability, not eliminate, but simply limit the liability. They already have full protection under the laws that as they exist today. So I don't, what's so exciting about this? I mean, to have them come in and say, yeah, well, use our link.
Right, and so as I understand these recreational use liability limitations, they were meant to entice private landowners to allow people to come on their property when private landowners could already claim, previously, if you just post your property, you already have some limitations on liability and some claims, and there are always attractive nuisance claims and misconduct and so forth. But the idea was to allow them to open their land or a portion of their land of public use by providing liability protection. So there isn't that concern of, well, if I allow you to run your trail across this property, the next time someone crashes their bike on the trail, I'm going to get sued. But again, this is the first time this has been testified on. And it's certainly not every state that has this sort of language, and I don't know what the arguments have been like in other states or the discussions. And then, this hasn't gotten testimony from the railroads, or the advocates, et cetera, on either side of this issue. And not the utilities either. So, yeah.
There's a lot more than this.
So there's one line bill.
Yeah,
Yeah, we tried it pretty well.
yeah, and it's good to do that, so. All right, where to go from here? Thanks, well, we have to hear from other witnesses. And we'll hear from the sponsor of the bill next, but we'll figure it out and hear from a few other folks. To see, I mean, I'm open to adding the line, something along the lines of not actively used for rail operations. And I think Senator Lewski made a point earlier that a railroad is, doesn't carry the same inherent level of risk as a fence or open and undeveloped land. So I could get behind adding a line not actively used for rail operations. But yeah, we'll see about that. Thank you. Any other questions for Dan?
Great.
So I think that's all we got for today. And actually, I'm looking at it. Yeah, well, right.